Welcome. Thank you for joining us for 3,600 Seconds. Tonight we'll be discussing the issue of affirmative action. It all began in 1978 with the Regents of California versus Bakke, which ruled that schools could not set aside a set number of spots in an incoming class for minorities. And the debate over affirmative action has been raging ever since. There have been a number of cases appealed to the Supreme Court in the 34 years since this decision, with a variety of different outcomes. This issue was reignited in 2003 with the University of Michigan cases, Gratz v. Bollinger and Grutter v. Bollinger. The court split on these cases, ruling the undergraduate policies in Gratz unconstitutional and the law school admission policy in Grutter constitutional. The issue in Gratz dealt with the use of different grids of GPA and test scores for minorities as opposed to Anglo-Saxons. And in Bollinger, the school simply considered race as a factor for admittance into the law school. This debate has been revitalized recently by the emergence of a case involving the University of Texas's admissions policy. Abigail Noel Fisher, a current senior at Louisiana State University, feels she was slighted by the admissions policy at Texas. As a side note, the Obama administration has supported Texas during this court's progression through the lower court system. In order to gain a better perspective on this case, we've brought an Associate Director of Admissions at the University of Texas, Demetrius Longhorn. Mr. Longhorn, explain to me and the rest of the country how the admissions process at Texas works.
Yes, well here at the University of Texas, we do grant preferences to students of certain races and ethnic backgrounds. Down here we have what was called the top 10% law, and it is a race neutral policy. And so the top 10 students of any Texas high school automatically get a seat at the campus of the University of Texas. The other students who aren't in the top 10, they get thrown into a pool of all the other students, and race is considered a factor.
Now, to what extent is race taken into account? Is it just another one of the factors, or is it more or less important than perhaps?
It's just another part of the factors. We don't have quotas.
Okay. Now, do you think that this policy complies with the Supreme Court's previous rulings?
Yes, absolutely. Based on Grutter v. Bollinger, this case shouldn't have been admitted by the Supreme Court. The Supreme Court ruled back then that it is constitutional to have race as a factor.
I have here with me the lawyer for the University of Texas, Daquan Kuzma. Mr. Kuzma, how do you believe the Supreme Court should rule in this case?
I believe that they will rule similar to Grutter v. Bollinger in that they will side for the University of Texas because they're not using quotas or tables in admitting minority students.
How does this case compare to previous affirmative action cases that the Supreme Court has already ruled on?
It's very similar to Gratz v. Bollinger in that there are no tables and no quotas used in the admissions process. Race is just one of the factors in admissions, and due to the past discrimination against minorities in the admissions process, I think that it's very important that race is just one of the factors in the admissions process.
Now I have with me the lawyer for Abigail Noel Fisher, senior at Louisiana State University, who's bringing this lawsuit on the University of Texas. How do you feel that the Supreme Court should rule on this case?
The admissions process here at the University of Texas is a clear-cut violation of the Equal Protection Clause of the 14th Amendment. It is clearly unconstitutional because what it does is that it automatically views those who come from an ethnic background other than Caucasian higher than those who are higher than those who are whites. That is violation of the Equal Protection Clause of the 14th Amendment. In segregation and post-segregation era times, just like the Regents of the University of California versus Bakke case, that would have been okay. You needed to promote diversity at that time, but now times have changed. That case was decided 34 years ago. The University of Texas especially is completely diverse and fully integrated, and there's no need to promote diversity because it is already diverse. And by promoting diversity, by using this system, you are automatically putting blacks or any other ethnic background higher than whites, and that is a violation of the Equal Protection Clause of the 14th Amendment.
Okay, why did the Supreme Court take this case?
I believe that the Supreme Court took this case because I think that the Supreme Court needed to kind of review the decision that they made in 2003, Grutter versus Bollinger, and it's been 7 years, well not 7, 9 years I guess, since that decision, and Justice Ginsburg said in that decision that I believe it was about within 10 years that the need for affirmative action would be non-existent, and I believe that that is why they took this case, because they need to finally decide the legitimacy of using affirmative action in schools.
Now that you've heard the facts in this case, it's up to you to decide. We won't know for sure how the Supreme Court rules until the end of the term. That does it for us here at 3,600 Seconds, and we hope you join us next week. So now that you've heard the facts on this case, it's up to you to decide. For the rest of us, we won't know how the Supreme Court rules. Yeah, I don't know why I said that. So now that you've heard the facts on this case, it's up for you to decide. We won't know how the Supreme Court rules on this until they come out with their decision at the end of the term. Now that you've heard the facts on this case, it's up to you to decide. We won't know for sure how the Supreme Court rules on this until the end of the... Jesus.